Today we are speaking with New York labor lawyer Abdul K. Hassan about wrongful termination of employment. Mr. Hassan, what is wrongful termination of employment?
Well, wrongful termination is where an employee's employment is terminated in violation of law, public policy, contract, or some other legal authority.
Can an employer terminate an employee without a reason?
Yes, most employees are considered at-will employees. This means the employer can terminate the at-will employees at the employer's will for no reason or any reason except an illegal reason.
What would be an example of an illegal reason?
An example of an illegal reason would be unlawful retaliation, unlawful discrimination, breach of contract, or violation of some other legal authority, such as the FMLA, the Family and Medical Leave Act, which generally guarantees reinstatement for a certain period of leave.
What is an example of unlawful discrimination?
An example of unlawful discrimination would be where an employee is terminated because of a protected characteristic, such as race, religion, national origin, age, gender, and so on. These characteristics are protected, meaning that they cannot be the basis for termination. And even if you are an at-will employee, if you're terminated because of one of these characteristics, the termination will be unlawful or illegal.
What's an example of unlawful retaliation?
An example would be, let's say an employee files a lawsuit to recover overtime wages. And then because the employee files that lawsuit to recover overtime wages, the employer fires the employee or terminates the employee's employment. The filing of the overtime lawsuit will be considered a protected activity under certain laws, such as the FLSA. And the termination of the employee because he engaged in this protected activity would be illegal and unlawful.
Are all forms of discrimination and retaliation unlawful?
No. This is a very common question that people ask about termination. And the only types of discrimination and retaliation that are unlawful are those that are specifically enumerated or specified in the law. The first question you ask when you're dealing with unlawful termination is whether the employee engaged in a protected activity or whether the employee was terminated because of a protected characteristic. The law protects characteristics such as age, religion, national origin, race, gender, and so on. So characteristics other than these, if they're the basis for the termination, may not render the termination unlawful. In terms of protected activities, activities such as filing a lawsuit to recover wages, opposing the underpayment of wages, or opposing discrimination or filing a charge of discrimination, these will be protected activities. And only those that are enumerated as protected activities would render an employment unlawful if the employment is based on such an activity.
Now, what if the employer terminates an employee without giving a reason or terminates the employee for a reason that's incorrect or absurd?
Well, if the employee is an at-will employee, the only time the employee can act on the termination and classify it as unlawful and maybe sue because of it is if it's illegal. If no reason is given, the employer generally is not required to give a reason. If the reason is wrong, let's say the employer thinks the employee did something wrong, and it turns out that the employee didn't do anything wrong. Even in that circumstance, the employer wouldn't be liable if the employee is at will. Even if the reason doesn't make sense, let's say the employer says, it's raining outside, therefore I will terminate you. Now that's a stupid or absurd reason, but it wouldn't be an illegal reason. So there's a difference between illegality and maybe absurdity and something that doesn't make sense.
Can an employer terminate an employee without giving notice?
Generally, yes. The employer generally is not required to give notice to an employee before termination, especially at-will employees. There are certain exceptions, such as under the WARN Act, the Worker Adjustment, Retraining, and Notification Act. If the employer closes a plant, if there's a plant closing or if there's a mass layoff, and the employer qualifies under the act, let's say the employer has more than 100 employees or so on, and meets certain other requirements, then the law may require that the employer provide the employee with notice before termination can occur.
If an employee is wrongfully terminated, what damages can be obtained in a wrongful termination lawsuit?
Well, there are a variety of laws which control termination, such as the discrimination laws, the retaliation laws, the Family and Medical Leave Act, certain workers' compensation laws, and so on. And these laws together provide a variety of remedies for a wrongfully terminated employee. But in general, an employee may be able to recover lost wages, back wages, or front wages. Front wages are wages which are the employee is reasonably likely to lose because of the wrongful termination. The employee sometimes can recover emotional distress damages. If the conduct was egregious or wanton or depraved, the employee may be able to recover punitive damages. And there also might be a basis for recovering attorney's fees and costs of the lawsuit and so on.
Are there any time deadlines that terminated employees should be aware of?
Yes, with any legal claims, there are always time deadlines that employees should be aware of and should be careful to consult an attorney about. If you are in a union situation, by the way, one example of wrongful termination because of a breach of contract would be in a union situation. If you're in a union, the union has a contract with the employer, which usually specifies that the employee cannot be terminated without cause or without committing misconduct. So if that contract is breached, then the employee would have a claim for wrongful termination. But in a union situation, sometimes you have less than 20 days or less than 30 days to initiate a grievance or initiate whatever remedial process is there for the employee. In a civil service environment, let's say you work for a governmental entity, there might be also very short time periods within which you must act, less than 30 days sometimes. And even when you file a suit in court against certain entities, you may have to take certain prerequisites and satisfy certain prerequisites within 30 days or within 90 days and so on. So it is very important that the employees consult an attorney as soon as possible to understand what type of deadlines that they're playing with and to act promptly to preserve their rights in the circumstances.
What's an important reminder that you would like to give to employees?
Well, the important reminder is that even though most employees are considered to be at-will employees, there are many exceptions to the at-will employment doctrine, many exceptions. And the employee must always try to consult an attorney who has expertise in the area of labor and employment law and who can evaluate their individual circumstances under these many exceptions and determine whether their termination was indeed wrongful.
We've been listening to New York labor lawyer Abdul K. Hassan. Mr. Hassan, thanks for answering our questions.
You're welcome.